My name is Manus Quigg. I'm a partner in Brodies' contentious construction team. I'm here chairing today's event, which is on the new JCT 24 D&B suite of contracts, what's changed and what issues arise from it. Our two speakers today are Craig Bradshaw, who's a legal director in our construction, infrastructure and projects team, and Connor Guinea, who's an associate in our contentious construction team. So without further ado, I'm going to hand you over to Craig. Thank you.
Good morning, everyone. So what can we expect from our webinar today? Well, our presentation is in 4 parts. In parts 1 and 2, we will be looking at the key changes. In part 3, we will provide some comment from a dispute resolution perspective. And in part 4, we will finish with some comments from a contract preparation perspective. So JCT 2024 brings in a number of changes. We're going to focus on the more substantive items today, so we'll move quickly through some of the slides. Next slide. Modernisation. Now this is captured well on the slide. Gender neutral language is used throughout. The footnotes on contract signing recognise the use of electronic signing, and we're finding that lots of people are using DocuSign these days. There's also the option to use email for notices and communications. You can even opt to use email for key notices like termination notices. Moving on to the next slide. Sustainability and environment. There's nothing too onerous for the contractor here. And this is an example of clauses being upgraded to permanent clauses that were previously optional clauses in the 2016 version. In essence here, the contractor is, in inverted commas, encouraged to suggest environmentally beneficial changes to the works. So there's no hard obligation being imposed here as such. Also, if requested, the contractor is to supply information on the environmental impact of the supply and use of materials and goods for which the contractor selects. Moving on to the next slide. A bit more to say here. As expected, the JCT contains some provisions relating to the building safety regime, which applies in England in response to the Grenfell tragedy. A huge topic in itself, not for today. The Building Safety Act 2022 is the key primary legislation. There are also various statutory instruments and changes made to existing legislation, such as the Building Regulations 2010 and the Defective Premises Act 1972. JCT philosophy is that the contract should say as little as possible about statutory matters. That's on the basis that there's already a general obligation in the contract to comply with statutory requirements. As a result, the new parts of the contract dealing with the building safety regime are relatively limited. The building safety regime has added a new Part 2A to the English Building Regulations 2010, and that provides for new building regulations duty holders. Conveniently and perhaps slightly confusingly, the new building regulations duty holders have the same names as the CDM duty holders. So there's the client, principal designer, principal contractor, contractors, and designers. The duties are, of course, different. The contract has new provisions relating to these duty holder roles as summarised on the slides. So there's space in Article 7 to insert the identity of the building regulations principal contractor and principal designer. The employer, in its building regulations client role, is to provide the contractor with, in inverted commas, building information, which is a defined term in the regulations. There are also new obligations on the employer and the contractor to comply with their building regulations duty holder roles. Next slide. Moving on then to look at design liability. The contractor undertakes a reasonable skill and care type of obligation for its design, similar to the kind of wording you might find in bespoke contract amendments used with the 2016 contract. So the contractor is required to use the reasonable skill and care to be expected of a qualified and experienced architect or other appropriate professional designer undertaking the design of works similar in scope and character to the design of the works. The contract also provides that the contractor A has no greater duty than to exercise reasonable skill and care. and B, is not subject to a fitness for purpose type obligation. Helpful changes here, as we're finding that contractors often want to exclude a fitness for purpose type obligation. Liability under the Defective Premises Act 1972. English law issue here, updated by the new building safety regime. Previously, the duties only applied in respect of new dwellings. They now also apply in respect of work to existing dwellings. So a contractor building or carrying out work to a dwelling will owe specific statutory duties to the person who instructed the work and also future owners of the dwelling. Next slide. This is a quick one. The slide says it all. The contract particulars relating to professional indemnity insurance, and that's in clause 16.15, have been updated to provide the parties with the ability to record sublimits within the overall level of cover and any exclusions from the professional indemnity insurance policy. Next slide. I'm going to finish the first section today with 3 slides dealing with termination-related points. Either party can still terminate due to the insolvency of the other, and in the 2024 update, the definition of insolvency has been updated. In relation to termination payments, there are actually some relatively extensive amendments to incorporate Construction Act compliant payment terms. Features include due date for payment, final date for payment, payment notice, payment counter notice, and pay less notice. There's also a new contractual right to late payment interest in the context of termination payments. Clause 8.11 of the contract has termination rights for both parties where the works are suspended due to specified events for a specified period of time. The default suspension period being 2 months. Epidemic has been added as one of the specified suspension events, and the change in law event is updated and extended. In each case, using similar language to that used in the updated extension of time and loss and expense clauses that we will look at later on. Next slide. So this is the second termination slide, and a new clause 229.5 has been added in response to the Supreme Court case of Triple Point Technology Inc. against PTT Public Company Limited. If the contract is terminated at a time when the contractor is in culpable delay, in other words, at a time when the contractor has failed to complete the works by the completion date due to its default, then the contractor will be liable for liquidated damages only until the termination date. After the termination date, general damages, not liquidated damages, would need to be claimed by the employer from the contractor. And moving on to the next slide. Third termination slide. The slide shows a simple contractual structure where a main contract between the employer and the contractor, a subcontract between the contractor and a subcontractor collateral warranty between the subcontractor, contractor, and the employer. The JCT main contract requires that subcontracts will terminate automatically upon termination of the main contract. However, step-in rights within the subcontractor collateral warranty will require the subcontractor and contractor to delay termination of the subcontract for a period of time to give the employer a chance to potentially step in and take over the subcontract in place of the contractor. So you've got a conflict. Main contract says subcontract to terminate automatically. Collateral warranty says termination is postponed for a period of time. So to address this, the JCT is updated so that in this kind of scenario, the subcontractor can suspend the subcontract until either A, it receives a step-in notice from the employer, or B, the period for step-in has expired. If the period for step-in expires without the subcontractor receiving a step-in notice from the employer, then at that point, the subcontract will automatically terminate. It should also be noted that suspension by a subcontractor in this scenario is treated as if it was an instruction by the employer. So handing over now to Connor, who will do the second stage of our talk today.
Thanks very much for that, Craig. If you just pop on to the next slide. So yes, I'll start off with a quick one and another clause that has been promoted from the optional clauses into the main form, and that's Article 3. So Article 3 now provides that parties are to cooperate and collaborate in good faith and in a spirit of trust and respect. And it also provides that parties are required to support collaborative behaviours and address behaviour that is not collaborative. And I'm sure you'll be aware that wording is very similar to that is found in the NEC suite of contracts, where parties are required to act in a spirit of mutual trust and cooperation. On to the next slide, please. Now, this is just another quick one, which is covered fairly fully on this slide. The previously defined term statutory undertaker has been deleted and replaced instead with statutory provider. The definition of statutory provider has been updated with the deletion of the words any local authority or statutory undertaker, and those words have been replaced simply with person. This change is reflected in the definition of statutory requirements, which again removes those words local authority or statutory undertaker and replaces them with person. Quite honestly, I'm not sure how effective these changes will be in practice in enabling parties to determine who in fact is a statutory undertaker or now provider. On to the next slide. Now, from a disputes perspective, one of the more interesting amendments or updates to the JCT DB 2024 arises at clause 1-8, which deals with the effect of the final statement. Clause 1-8.1 remains unchanged, and that's safe in circumstances, providing clause 1.8.2 and 4.24.6 that from the due date for the final payment, the final statement shall have effect in any proceedings under or arising out of or in connection with the contract as conclusive evidence that, for example, that a particular quality of materials or goods, etc., was to the employer's reasonable satisfaction. All and only such extensions of time as due have been given, and the reimbursement of direct and or loss and expense due to the contractor as agreed, ascertained or valued is in final settlement of all and any claims which the contractor has or may have arising out of the occurrence of any relevant matters. So as you see on the screen here, clause 1.8.2 of Design Build 2016 provided that the effects of the final statement would, in relation to the subject matter of any adjudication, arbitration or proceedings, be suspended pending the conclusion of such proceedings. The JCT drafting boards have concluded that the earlier wording in practice would give rise to disputes concerning the extent of the suspension, particularly where the scope of the proceedings was unclear. Therefore, disputes would arise as to which parts of the final statement were actually held as being conclusive. So, to resolve this, JCT have revised the wording of clause 1.8.2 as now shown on the slide. So now, the conclusive effect of the final statement shall be suspended pending the conclusion of any adjudication, arbitration or proceedings which are raised within the appropriate timescales. So therefore follows that if proceedings are commenced in accordance with the timescales outlined in clauses 1.8.1 and 2, there shall be a complete suspension of the effects of the relevant statement or final statement pending the conclusion of those proceedings, irrespective of what those proceedings actually relate to. Following the conclusion of those proceedings, the final statement will be subject to the terms of any decision, award, or settlement of those proceedings. Now, of course, the possibility still remains that disputes are going to flow as to how the terms of any decisions, award, judgment, settlement affect the final statement. But the revisions introduced by the JCT do provide certainty as to the date in which the final statement becomes conclusive evidence and in what respect. And just finally, keeping with clause 1.8, one further change is that the timescales in which you're required to commence your proceedings, which will suspend the effects of the final statement, is now tied to the due date for final payment. as opposed to the date of issue of the relevant statement, and that is a welcome change which will offer parties additional time in order to raise the appropriate proceedings. And if we move on to the next slide, please. Okay, coming now to clause 3.15, which was antiquities, it has now been extended to include also asbestos, contaminated materials and unexploded ordnance. So upon the discovery of any asbestos, contaminated material or unexploded ordnance on the site or in excavating it during the progress of the works, the contractor is now required to, number one, use best endeavours not to disturb the material or item and cease work if and insofar as continuing works would endanger health and safety and or life and property or prevent or impede the disposal or removal of the material or item. And secondly, they're also required to report the discovery of such material or item and the steps that it's taking to deal with the item to the employer. From the employer's perspective, it has the power to issue instructions in relation to the discovery, which could include requiring the contractor to permit the investigation or removal of the item by a third party. Now, I can appreciate there may be queries in respect of the contractor's entitlement to time and money upon the discovery of these materials and items, which actually takes me on to my next slide, which relate to extensions of time and loss and expense claims. So this first slide here summarises the changes in relation to relevant events and relevant matters. Relevant events being the various events that can entitle a contractor to an extension of time, with relevant matters being the various matters which can entitle the contractor to loss and expense. So I'll take each of these in turn. The contractor is now entitled pardon me, to apply for an extension of time and loss and expense if it is delayed as a result of what we have just discussed, i.e. the discovery of asbestos, contaminated material or unexploded ordnance. It is entitled to do so except to the extent that the presence of asbestos or contaminated material had been identified in the contractor's document and or if any such material has actually been brought onto the site by the contractor or any contractor's person. Moving now to epidemics. So taking into consideration lessons learned from the COVID pandemic, contractors will now be entitled to apply for an extension of time if it is delayed due to an epidemic which impacts on labour, services or materials. Interestingly, this doesn't apply only to epidemics which occurred during the currency of the works. Epidemics which have occurred before the base date, but the effects of which have changed after the base date, which then impacts on the execution of the works, are also covered. Now, whilst the contractor can apply for an extension of time in these circumstances, it should be noted that the standard form does not provide a right to loss and expense for epidemic-related delays. This is optional only, so parties would need to select this within the contract particulars if they wish for it to apply. And finally, the exercise of a statutory power, including a change of law and the publication of guidance, is now being included as a relevant event if it affects the execution of the works. In the case of guidance, the guidance that is referred to, and this is clarified within the contract form itself, is that guidance that is issued by the Construction Leadership Council or its successor. Now, in the same manner as with epidemics, the standard form does not include the exercise of a statutory power as a relevant matter, but the parties do have the option, again, to select this as a relevant matter within the contract particulars. Next slide, please. So this second slide covers the administrative changes to the extension of time regime. So firstly, the Design Build Contract 2024 has actually shortened the time period for an employer to notify of its decision on an extension of time following the receipt of notice and particulars from the contractor from 12 weeks down to 8 weeks. In addition, it has introduced a time limit on the employer requesting further information from the contractor to enable it to reach a decision. So if, upon receiving particulars from the contractor, the employer considers it requires further information as is reasonably necessary, and I'll come back to that point, to enable it to reach a decision, then not later than 14 days from receipt of the particulars, it must notify the contractor stating the further information required, and the contractor is under an obligation to supply that information as requested. A further mechanism that has been introduced is where the contractor gives notice of a material change in the estimated delay or in any other particulars. In such circumstances, the employer remains under an obligation to notify its decision to the original notice and particulars within 8 weeks, unless further information has been requested. And it's also under a separate obligation to notify its decision in respect of the notice of a material change within 8 weeks of that notification. One point that I should cover here is that the deadline for an employer issuing its decision, which is 8 weeks, is delayed if the employer asks for further information from the contractor. In those circumstances, if the employer requests further information, which it must do within 14 days, the 8-week period does not run until such time as the contractor actually provides that information. And again, I'll discuss this further in due course, but just want to be aware of. In making these changes, the JCT Drafting Committee has advised that its decision was to improve the efficiency of the decision-making process. For now, I'll say that the updates do appear to provide a kind of breeding ground for potential disputes. But as discussed, I'll come back on that point in due course. And next slide, please. So this brings me on to my final slide on the changes in the contract, and that is in respect of the new clause 9.1, notification and negotiation of disputes. So clause 9.1 now places an obligation on parties to promptly notify the other of any matter that appears likely to give rise to a dispute or difference, and provides that senior executives nominated in the contract particulars, or if either is not available, a colleague of similar standing, shall meet as soon as practicable for direct, good faith negotiations to resolve the matter. And that brings me on to my next slide. So I'll just give a kind of brief overview of some issues and potential issues that have arisen as a result of the changes introduced in the new contract. And I want to first start on 2 items that were covered by Craig earlier on. First is the requirement in clause 2.2 that the contractor shall provide to the employer all information that the employer reasonably requests regarding the environmental impact of the supply and use of materials and goods which the contractor selects. So environmental considerations in building projects is obviously a growth area, and with that it will bring risk for contractors in selecting and specifying materials, noting that they will achieve certain environmental performance characteristics. There could be a liability if those materials as specified do not in fact meet those characteristics, and as a risk moving forward for contractors. We do expect to see more disputes in this area in the short term as the industry does become more environmentally conscious. Secondly is the change at 2.17.2 with regards liability for design work. So clause 2.17.2 provides that to the extent permitted by statutory requirements, the contractor shall have no greater duty, obligation or liability than to exercise reasonable skill and care in respect of such design, and under no circumstances shall the contractor be subject to any duty, obligation or liability which requires that such design shall be fit for purpose. Now, this wording within the standard form does remain to be tested to ensure that the specific performance obligations cannot be imposed on a contractor through the back door via CPs or ERs, i.e. with more specific onerous obligations overriding the general duty to exercise reasonable skill and care, as was in the case of MT Hoygaard against E.ON. Given this, it will be interesting to see how employers will actually approach the inclusion of this wording in the new form and how it may be amended in due course by contractors. If we move on to the next slide, please. I also wanted to touch briefly on a section of the contract that was not amended, and that is in respect of the notification requirements for loss and expense claims. Now, you may or may not be aware of a decision published earlier this year in the Court of Session, where it was held that compliance with the notification requirements in the SBCC standard form was a condition precedent to entitlement to loss and expense due to the inclusion of the words highlighted on the slide, that you should be entitled to reimbursement of that loss and expense subject to compliance with the provisions of clause 4.20. which is the notification provisions. Now, at the JCT launch event, this query was actually raised to the drafting committee as to whether or not they thought, in their view, that clause 4.19 made compliance with the notification and ascertainment provisions a condition precedent to the reimbursement of loss and expense. Now, rather interestingly, the drafting committee responded with a resounding no. Nevertheless, it actually advised that Design Build 2024 was already in print at the time the judgment was issued, and they did debate at that point in time as to whether amendments should be made. But they took the view that they would be best placed to wait and see how the English courts approach the issue before making any amendments. Now, it is likely that there will be further developments in this issue in due course, given the impact of the decision in the sector. For now, our recommendation would be for contractors to ensure that at all times they are adhering to the notification provisions under clause 4.20. Next slide, please. And now I wanted to come back to the administrative changes within the EOT procedure. And I wanted to give a brief discussion on how the mechanism is actually going to operate in practice, how it could operate in practice. So I'll begin by saying, in principle, the mechanism introduced does offer certainty to the contractor that following the expiry of the 14-day period, following particulars being issued, that the employer should not be asking for any further information from the contractor. However, when you play that through in practice, it really does take you in some interesting directions. So there are going to be circumstances, or it is likely there are going to be circumstances where an employer simply does not have the capacity to fully consider the particulars and information provided by the contractor to enable it to determine if it requires any further information to enable it to reach a decision within 14 days. The employer could then find itself in a scenario whereby it has no option but to issue an all-encompassing list of information from the contractor. The difficulty with doing so, however, and as I touched on this before, the information requested must be reasonably necessary to enable the employer to reach a decision. Now, what could happen here? The contractor, on receiving that request, could say that information is not reasonably necessary in order for you to provide a decision. And that places both parties in a difficult situation. The employer, having made the request, is then under no obligation to issue a decision until such time as the contractor provides the information. The contractor, on the other hand, may be unwilling to hand over the information, as it doesn't believe that information is reasonably necessary. And if the employer then refuses to issue a decision within the 8-week period, the contractor will have no option but to commence adjudication proceedings for determination of the issue. And this introduces risks for both sides. The employer at adjudication could be found to be in breach of contract by failing to issue its decision after 8 weeks as a result of requesting information which was not reasonably necessary to enable it to reach a decision. And in those circumstances, the decision-making process as to the contractor's entitlement will be handed over to the adjudicator. There's also a risk to the employer that by putting forward a position in the adjudication as to the contractor's entitlement, which would obviously have to be under reservation of his position that it requires further information, could be seen to be demonstrating to the adjudicator that it could, in fact, have reached the decision without the requested information. However, from an employer's perspective, it would be too much of a risk not to present a case based on information before it, given that the decision on entitlement could be put into the hands of the adjudicator. Now, for the contractor, in arguing that no further information was required by the employer in order to enable it to make a decision, it could in theory be limited to rely solely on the information already provided to the employer at adjudication, or else it runs the risk that the adjudicator may determine that in actual fact further information was required and the employer's request for documentation was reasonable. In those circumstances, the adjudicator could simply determine that information should be provided, and that in those circumstances, the adjudicator was not determined to take a view on entitlement, and that the 8-week time frame for a decision has not yet commenced. Further, one issue for the contractor is that if it is required to go to adjudication, the first time it may actually obtain an employer's view on its entitlement based on the documentation before it, the first time that will happen is in the adjudication. And given the tight timescales in adjudication, the contractor will only have a limited time to actually consider the employer's position and respond to the same. So as you can see, there's a host of different avenues and different pitfalls that parties could find themselves in as a result of the changes here. So it will be very interesting to see how parties approach these issues in practice and how matters will develop in due course. And I will now pass you back on to Craig, who will provide some further commentary from a contract preparation perspective. Thank you.
Going to finish our presentation today by looking at 5 contract preparation points, some high-level practical points here, and these highlight ways in which the JCT is not always oven ready. Moving on to the next slide. JCT D&B contract 2024 is, of course, a design and build contract. However, it does not provide the employer with a single point of responsibility for design and construction. The 2 key technical documents in the contract are the employer's requirements and the contractor's proposals. And as shown in the slide, as between the employer and the contractor, the employer is responsible for the design contained in the employer's requirements. The contractor is responsible for the design in the contractor's proposals and the design it completes during the construction phase. This means that if there's a defect in the design, that the employer's claim therefore might be against the contractor, the employer's design team, or both. And this is not ideal from an employer's perspective. Moving on to the next slide. In most projects that we're working on, the employer wants a single point of responsibility for all design and construction, so that the contractor is responsible for the design contained in the employer's requirements and the contractor's proposals, and all design prepared during the construction phase. To achieve this, the JCT needs to be amended and to provide for novation of the design team to the contractor, as shown on the slide. An English building safety regime point here. The JCT has actually published an additional guidance note explaining that the contract does not contain clauses that might be required if the project is for a higher risk building under the building safety regime in England. So if you're using the JCT for a higher risk building in England, consideration needs to be given to having additional clauses. The JCT highlights that additional clauses may be required in relation to the golden thread information requirements and the new gateway system of regulatory checks. So one to watch out for. Moving on to the next slide. The JCT doesn't contain an overall aggregate cap on the contractor's liability. If this is required, it will need to be added to the contract, and that's something we're seeing coming up from time to time. For the first time, the JCT has included some guidance notes within its guidance with commentary on this subject, and that's worth having a look if this is something you need to deal with. Moving on to the next slide. Often contracts will require collateral warranties, a performance bond, or a parent company guarantee. The printed JCT D&B 2020-24 doesn't include templates for these documents. These are things that will need to be obtained and added if required. So again, contract not always going to be oven ready. Moving on to the next slide. This is a final point today. Building contracts between employers and contractors do not usually exist in a vacuum. Often the employer will have a funding agreement with a lender, or an agreement for lease with a tenant, or maybe a development agreement with a purchaser. Often these third-party agreements will impose construction-related obligations on the employer, and the only way for the employer to discharge those obligations will be to pass them on to the contractor. To do this, a third-party agreements clause will need to be added to the JCT, and that will be required in order to make sure the employer passes those obligations down to the contractor. So thank you, everyone, and handing back to Manus for a wrap-up and questions.
Thank you very much. Craig and Connor, you can both put your cameras on, please. I'll be asking you some questions. I've got some for you. And probably the first one is for you, Connor. Connor, the obligation to act in a spirit of mutual trust and cooperation is obviously a new concept to JCT. How would you expect that to be applied in the dispute scenario?
Yeah, no problem. The court of review, just touching on the issue of good faith to begin with, the Court of Appeal in England have actually issued guidance on this point, how it's interpreted, and their explanation is that the duty of good faith could be seen as a duty to act honestly and would prohibit conduct that reasonable and honest people would regard as commercially unacceptable, but not necessarily dishonest. It's important to note that the courts have been particularly cautious in extending the duty of good faith beyond those bounds without any clear context. It's more likely or not that the provision won't be interpreted, the provision should not be interpreted so widely as to introduce any obligations not intended by the parties or to fundamentally change the contract. So on balance, it's more likely than not that the duty is going to be a filter in which the courts will view other breaches under the contract.
Okay, thank you. Next one's for you, Craig. There's no collateral warranty in the new form of contract, but there is a schedule of third-party rights. Can that be used instead? And if so, what is the advantages of using that schedule over a collateral warranty? Double-barrel question.
Well, yes, there is a schedule of third-party rights in the JCT contract, same as there was in the 2016 version, and that's unlikely to be used on the drafting that's contained in the contract because it's really an off-market version of the kind of third-party rights we would expect to see. The JCT 2024 version is similar to the 2016 version, and it contains certain limitations within the third-party rights for purchasers and tenants and for employers that will be unacceptable from a beneficiary's perspective. So again, not really oven ready, if you like. If anyone was going to use those third-party rights, they would definitely need to amend them to make them suitable for use with the relevant beneficiaries. In terms of whether a third-party rights or collateral warrant is beneficial over collateral warranties, in substance, they're both the same. They provide third parties with the same rights of recourse. And what we're finding in the market is that collateral warranties continue to be overwhelmingly the preferred approach. And in fact, I think certainly post-pandemic collateral warranties are even more convenient given that people are using DocuSign these days to sign documents. So I think previously third-party rights were viewed potentially as slightly more convenient because there's maybe a bit less administration involved. But the way we're doing collateral warranties these days, that difference doesn't really exist. And people still like to have their collateral warranty because they can see a document that's theirs and has all the rights and obligations in it. So I think that's what I would say there.
Okay, thank you. Next question is for Connor. Connor, in relation to loss and expense clause 420 in the court case you're referring to, the FES case, you said the JCT's position and notification requirements for loss and expenses that they're going to wait to see how the English courts interpret that position. Do you believe it's likely that the SBCC equivalent in Scotland, when it's issued, will it update its clauses given that the FES decision was a Scottish one?
It remains to be seen. I know earlier on there's likely to be further developments given the impact the decision will have on the industry. But you know, it's not something I can comment on just now until the SBCC issue the contract. But I would expect that it's unlikely that the SBCC will vary the drafting from the wording within the JCT contract. But we should find out later on in the year, I think, is when the SBCC contract is due to be issued.
Okay, so the risk remains then of being held to be a condition precedent,
yes,
and with the resultant obligations on contractors for notification. Okay, and the another question that's come in is, when will the SBCC versions, the other versions, presumably be available? Do either of you know when they're likely to be published? Is there any dates for that yet?
I know the SBCC haven't confirmed a date yet. They've just said they are considering the changes and they will provide an update hopefully later on in the year. I know the minor works contract, JCT minor works contract is now issued and available, but I don't believe that there's been any further set dates for the remainder of the contracts.
Okay. Another question that's come in for you, Connor, is does the obligation to inform the other party of a potential dispute act as a de facto early warning notice, whereby you must give the notice of an irrelevant matter or event that could reasonably foreseeably occur?
Can you just repeat that one for me, Manus?
I'm just going to read it again, if that's okay. Does the obligation to inform the other party of a potential dispute act as an early warning notice, whereby you must give notice of a relevant matter, a relevant event that could reasonably occur? I think that might be confusing two different things. I think that's confusing notification, the obligation to notify a relevant matter and a relevant event, with the obligation
to notify dispute.
It must be the ranking provision, the escalation provisions within the dispute resolution provisions. Do you want to discuss that a wee bit?
Yeah, I don't think the two of them would speak to one another in the sense that your obligation to notify of the dispute shouldn't relate to your obligation to give notice of a potential delay. In the sense that, you know, you may give an early warning notice and you may then thereafter apply for an extension of time and there may be no dispute on that basis. I don't know if I'm picking up the question incorrectly, though.
I think the question might also be aimed at that. I think that's right. There's the distinct obligation to notify for a relevant event and a relevant matter, and that's distinct from that doesn't necessarily mean that there's a dispute. That's you notifying your entitlement under the contract. I think perhaps the question is aimed maybe at is it a condition precedent to entitlement that you notify the dispute timeously?
Okay, and no problem. The answer to that is probably no. In the sense that you'll still be able to, it will not cut across your ability to refer a dispute to adjudication at any time. And also the wording isn't in such a manner in which it deprives you of the right to commence proceedings if you have not first given that notice. So no, I don't believe it will be a condition precedent. But obviously the courts may interpret that differently. In actual fact, in giving the in their introductory presentation following the release of this contract, the JCT actually included within their slides, this is not a condition precedent, albeit the courts may interpret this differently. In my view, it will not be interpreted as a condition precedent.
Okay, thank you very much. And Jay, I hope I didn't butcher your question too much in the asking. Well, thank you very much, ladies and gentlemen. I think that's our time has run out now. I hope you've found it informative, the presentation. Thank you very much to both our speakers. If you have any further thoughts, please do get in touch to let us know, because as we start to use these contracts, no doubt, as always happens, other issues will arise that we're going to have to get our heads around and work out what advice we're going to give and what strategies we should be developing for entering into the contracts event. But thank you very much in the meantime. Have a good day.